let's start with our discussion 2, that is global IP protection strategies, giving design its place in the sun. We have our panelists joining in. We have Stephen Yang, Managing Partner, Patent Attorney from IP March. We have Hongming, he's a Senior IP Counsel from Tencent America. We have Diane, Lettelleir, Senior Managing Counsel, JCPenny. We have Luisa Fernanda, Herrera, head of the IP department. So she's head of department at GHA IP Lawyers. We have Dr. Abiola, Inniss, Executive Director, Caribbean and Americas Intellectual Property Organization. And one and only our moderator for today's session, that is Chike Ekwueme. He's a managing partner from Ekwueme and Ekwueme Partners. So over to you, Chike.
Thank you, Mitali. The topic again is global IP strategies, giving design its place in the sun. By the very wording of that topic, you would appreciate that it is an international, multinational, cross-border issue, IP protection globally, and therefore it is very apt that we have a multinational panel to discuss this subject matter. We have decided that we would go around, each person would take a few minutes to talk about certain points that are relevant to the topic, and then we'll take questions from the audience, from the other participants. And so you're invited to place your questions in the chat box as the discussion progresses. From time to time, I would be intervening to maybe seek clarification or highlight a point I think that might be of benefit to all those who are participating. During our call session before the conference, we decided that Diane would go first. So let me welcome Diane Lettelleir to talk briefly about a few issues. She will be speaking about general issues in software. Trends and inconsistencies in copyright case law and some other aspects of the topic. So Diane.
Thank you, Chike. And good afternoon to all. I hope you've had a good conference so far. I wanted to talk a little bit about the status of copyright litigation in the United States, because it does dovetail into the important considerations when you're evaluating whether or not to pursue design protection. In the last year in the US and various courts, we've seen a lot of inconsistencies in the handling of copyright cases, and we've seen where it's very difficult to resolve copyright cases in the early stages of litigation from either side, plaintiff or defendant, but particularly with respect to the defendants. But there's so much uncertainty with respect to the way the copyrights are being applied that it does leave an opening, a continued opening for design patent protection. In the copyright arena, we've seen where courts continue to focus on generic alleged similarities between works. And that makes it very difficult to dispose of cases in the early stages, because instead of focusing on just the protected elements of a work, there's a tendency for courts to look at the generic elements, and in doing so, it can encompass an entire genre of works, which of course does make copyrights more powerful than they might otherwise be in terms of litigation strategies, because it's very difficult for the defendant to get rid of the case in the early going. And there's just this continued failure of the courts to distinguish between protected elements and unprotected elements of the work. It's very difficult for judges, it appears, to really discern those elements, even in courts that routinely are presented with copyright cases and should be very familiar with the law and the standards. It does seem that copyright plaintiffs are particularly successful in blurring the lines between protected and unprotected elements of the works. There's also been some areas that are very relevant to today's consumer marketplace that have been thrown into relative disarray because of a few court decisions. One example is where a tattoo artist claimed copyright interest in the tattoo art that was applied to a famous person, who then licensed his likeness to a company for marketing purposes of other products. The copyright artist that was alleging copyright interest in his tattoo challenged that license saying that she had not granted a license to her work, being the tattoo that was applied to that person's body. So it really, it basically says that a person that has a tattoo doesn't own the rights to his full likeness. And, that case is still up in the air. At the last I checked, it was set to go to trial next month. So we don't know exactly how it's all going to come out. But the important aspect is that the copyright plaintiff got beyond the initial pleading stages in the case, which of course threw the entire transaction into uncertainty, and it's been very disruptive because many famous people have multiple tattoos, and to try and go back, if they didn't negotiate a proper license from the tattoo artist that would clearly delineate that person's right to his likeness, then it's very difficult to go back and recapture those rights. And another area that's really swirling now in the US is the right to embed publicly posted Instagram photos in subsequent works, whether it's a journalist work or just an individual's work. That has been thrown into question because Instagram has taken the position that while under its terms of use, if you post a photo to Instagram, you grant Instagram the right to sublicense. But that's not the same then as Instagram having actually sublicensed those rights to a third party. So Instagram itself has thrown a wrench into that particular area of the law. So there's, given the amount of embedding that is occurring in images in other works after they've been posted to a public social media site, it really requires reconsideration of your rights. And that's really important for a lot of companies that have Instagram accounts that allow their consumers or their customers to post information and photographs, and then they embed it into a company website, for example. There's a lot of care that needs to be taken now with respect to that because of the uncertainty. So while copyright protection remains a really important element of any intellectual property portfolio, design patents really have been underutilized. And I just realized I've already used all of my time. So I was timing myself. I don't talk as fast as I think I do. But let me just say really quickly on the design patents that they are underutilized. And it is really important now. They've gained a lot of importance in the US, and particularly if you're taking a consumer product to market, adding design protection to your portfolio in addition to any utility protection you have, I think is a really key consideration, because consumers and even other, whether it's a corporate consumer or a public consumer, are very driven by the aesthetics and the look of a product. And if someone is looking at knocking off your client's product or your company's product, being able to protect the look and feel, the look of that product is really important, because even though the interloper may alter the inner workings of a product so it does not infringe a utility patent, they likely will try and make their product look like the patent owner product. And so adding a layer of design protection that protects the aesthetics and the look of the product can really help in terms of distinguishing between your product and a potential infringer's product before you ever get into the details of how the product works. So it really helps in terms of the initial confusion that can occur with consumers, whether it's a business consumer or an individual consumer, when they're in the marketplace shopping for a product. So I apologize for going over, and I'll yield, sorry.
Thank you so much, Diane. I would say that very interesting points made, particularly the story about the tattoo, the rights in the tattoo. I mean, I'd never even thought about that. And the point you made about design patents and protecting the aesthetics as well as the technical workings of a product, I think are very. We want to go straight to Hongming, who will be speaking very briefly on general issues in software patent protection and some other matters that are relevant to today's topic. Go ahead.
Hi, everyone. I'm a Hongming Liu. I'm very glad to have this opportunity to share my experience. I work in Tencent American part. Tencent is a Chinese company based in Shenzhen, so mostly social media and gaming. So my job is in charge of the patent portfolio. Many of the invention come from China, and including mostly software patent, some design patent, because we are using design patent, like Diane said, a very important tool combined with software. So I wanted to mention one thing that's really difficult in software patent management. So which stems from my background. I was a software engineer for like 15 years before I was a patent attorney. So which really gave me a perspective kind of in between. So which in turn remind me a story that when I first came to the United States, right before I came to the United States, I was in a train station in Shanghai. And on my left side, I saw a sign in Chinese saying, jumping on the rail is prohibited. On my right-hand side is the Nike advertisement, just do it. So standing between give me a very interesting perspective. So it comes to, so working in the patent industry, having this engineer background, give me a perspective that I like to share, which is it's very difficult to patent software, to protect software using patent. There's a lot of challenge. And the biggest one is an invention, a software invention is written in computer code. It's a work product of a software engineer. It's very hard to describe that in terms of invention. So on one side, you have thousands of lines of computer code. On the other side, you have to describe as something that in the plain language. So that translation is difficult. So one thing is it's difficult to understand the work product in the first place. When I was a software engineer, one thing that I hate the most is to read somebody's code without a comment. And the second thing I hate the most is to write a comment. You see the problem? It's very hard to communicate a piece of code that's written to fulfill a functionality. But we have to do that when we need to protect our part. And when we speak of design patent, you might think, oh, that's probably easier. However, in software patent, design patent is so intertwined with the software itself. We will only protect the design aspect of a software patent when the software functionality is complicated. And so I just want to point it out because that has been really make my job challenge, and I think it will make a lot of colleagues in this field challenging too. So, and my personal viewpoint on that is we have to face the challenge, we have to acknowledge the challenge, and also when we are managing our portfolio, we have to look really carefully how our software patent cover the product, because this challenge, we have a lot of software patent that's not actually covering the invention. The translation got lost. So that's the biggest takeaway. I think I'm about to use up my time. So I'm very glad to share with you, and I'll yield back to Chike.
Thank you so much, Hongming. Very interesting points made, and I'm also particularly interested in the point you made about a lot of protection of patents of inventions made in China in the US. That's a very interesting phenomenon. I want to hear from the birthday boy at this time. So I want to yield the floor right now to Stephen. He'll be giving us a little teaser on the current design practices in China and some other topics.
Thank
Go
you,
ahead,
Chike.
Stephen.
And thank you for the birthday wishes at the IPR Gorilla conference organizers. My talk, I'm a Chinese patent attorney, and design has been a big part of my practice in the past 24 years. In China, actually, filings, less than 1/3 are design patent applications. So we're talking about 700,000 per year. And among that, most of them are filed by Chinese applicants. I think the foreign applicants' filing numbers are maybe just a few thousand. So this is pretty much favored by Chinese applicants because they understand the appearance can help the sales a lot. So you make a product that's really appealing to consumers, and it's going to sell well. But unfortunately, the design practice in China has been pretty strict. So you need to submit 6 views, direct projective views, to describe your product. And these views should correspond to each other. So if you have a product that can have multiple states, let's say a folded state, an extended state, you should have views, let's say for each of these states. And for each of these states, you should have 6 views. And in each of these states, these 6 views should correspond to the exact same state. And you need to have the mechanical background to understand why examiners raise objections. They will say, oh, there is a protrusion that should be visible from the left side view, but you didn't describe it. So that's wrong. There's an objection, you have to correct it. So you're going to receive objections like this, which pretty much you wouldn't if you file a EU application, design application. So you need help with attorneys with mechanical background or a draft person that can understand this kind of objections to help you with the drawings. And in addition to that, up to now, we still require all the lines are solid. So for a part that cannot be sold or used independently, you cannot protect it independently with a design application. For example, I have a major sportswear company client that want to protect a certain part of a shoe, which doesn't have its own function when in actual use. It's just part of a shoe upper. They couldn't do that. They have to file the drawings for the whole shoe with every line solid. You cannot do the disclaimer like in the US by now, but we will soon be able to do that because China is going to have a new patent law and the effective date is June 1st this year. So when the new law takes effect, you will be able to do something like in the US to disclaim part of the product, which has not to do with the key design point with dotted lines. So use dotted lines to describe those parts and use solid lines to represent the true design elements, the key points of your design. So in terms of that, there's a sort of harmonization between the Chinese design practice and the rest of the world. So that is a big step, but we don't have the detailed rules yet. So what is allowed, what is not allowed. So this is not clear yet. And a second thing about the design changes is that China is getting ready to join the Hague Agreement. So very soon, I think we're going to expect that China is going to be part of the Hague. And there is a whole chapter, brand new chapter in the implementing regulations of Chinese patent law that is directed to the Hague Agreement. It's being drafted. But as far as I can expect, You cannot expect that you will file your design application in your home country or in the International Bureau and automatically get a design registration in China. That will not happen. I think the Chinese examiner will still do their own examination. You're going to get objections and rejections. You still need a local attorney to help you with that. And my last point, it has to do with some software. Like Hongming said, Tencent is a software company, and design can be also useful for software companies. Like Tencent or Baidu or Alibaba, they file a lot of design applications, but they don't produce physical product. If they do, they would have been filing a huge number of design applications. But even if they don't, they still have a lot of design applications because you can protect graphic user interface with design applications. I see a lot of these applications filed by software companies. So that is another useful aspect of design. And because now we're allowing this partial design, so you can actually just protect the GUI itself without limiting your GUI as part of a complete product. For example, if you have a fridge with a GUI module on it, you don't have to protect the fridge anymore. You can protect the GUI itself. And even among the GUI, there are certain elements that you don't want to protect. You can disclaim them with dotted lines just to protect certain things in the interface. So that will be very interesting to software companies. So with that, that concludes my part of the presentation. Over to you, Chike.
Thank you, Stephen. I do believe that this is to participants that might be looking at filing for design protection in China, which of course, the size of the market there. So thanks so much for your insights, Stephen. We want to now move to Abiola, Dr. Abiola Inniss. She'll be giving us some insights into some tips for IP protection in the Caribbean. Maybe I think we would take Luisa's presentation while we wait for you to connect. We have Luisa.
Fernanda.
Let me be sure of your
yeah,
name.
Is that
Fernanda? Is that correct?
Thank you so
Fernanda.
much.
So please go ahead. Okay. So,
Thank you. So thank you so much. Thank you so much for all the attendees, and also I'm really grateful with IP Gorilla conference. It's a pleasure and an honor to be able to speak among all of you experts about all this practice about design in other countries. And for me, it's a pleasure to present some issues here in Colombia and some practical topics. So today I'm going to talk to you about some generalities of design protection in Colombia, but also which ones generate more issues or more problems. Especially one is related to the one that in China were spoken before, about the graphic representation, especially using dotted lines or broken lines in the graphic application, in the graphic representation, because they are not allowed here in Colombia, and legally is not embedded like this in our law. But in practice, our IP office doesn't allow to do this kind of representation. I agree, as before it was said, but by the first to speak, by Diane. I agree that the common point also is actually what is actually protectable. It is interesting to see, and I want to say this, that how this strategy are built in that sense. In the United States, for example, and you were talking about design patents. In Colombia, we have patent, which is possible, but only that would be to protect the utility, the application, but not the ornamental or the way is looked the product. For example, here in Colombia, we have a famous case about the protection of a shoe, Crocs design the crux is the trademark, and the design was protected as a patent in United States, but in Colombia it was refused this designed application. Here it was only possible to do it through a trademark, but not through design. So this, to decide which way is the best way, is very important, but for this is relevant to know how our IP office is demanding and is requesting to do the graphical representation. So I'm showing right now in my slide some examples about this. I would like to start with the following sentence before showing the example, because the delimitation of the scope of rights in Colombia is crucial when requesting an intellectual property registration, if it is a design or trademark or even a patent or even the Copyright Office. Crucial is to demonstrate what are the borders of the right to be certain, and there is some requirement about the certainty of the right. J. Davis once said, authorities should be the gatekeepers, and actually our IP office is doing this. It is not a secret that when the criteria or requirements of protection are properly applied, competition likewise is protected and competition is promoted. In the strategies adopted for the protection of designs, it is important to bear in mind that in Colombia, is, as I said, very different from other legislations like in the United States. So generally in Colombia, there is not so much clarity, as I said before, about broken line, and generally by practice, only by practice, but not because the law is embedded this. By practice, the dashed lines or the broken lines are not accepted, as I am sharing with my slide, which I will be explaining soon. Our IP office is more strict about the graphic representation then, and for that reason, it is suggested not to use them in our applications. However, Colombia is in the process of entering right now into the hack model of industrial models and designs that would imply a legislative amendment in other matters, such as other provision at the local level in other countries. And here in Colombia, it would be a change in our practice in our IP office. So regarding the first example, as you can see, if you can see the first example, which is the right one, it's the dot line, the broken lines of a shoe, of the upper side of a shoe, of a sports shoe, and it was applied, but the registration, the application was denied, was refused by the Intellectual Property Office of Colombia, considering that it's not an industrial, is not a design to be protected in Colombia, because by eliminating the broken lines or in the invisible lines, the form becomes incomplete. The design refers to a three-dimensional object, and if the lower lines disappear, the design remains without support. Since the three-dimensional sign must be shaped by a closed figure that occupies the space. The second one, the second example, the figures of this is different because it's not broken lines, but exploded views. And with exploded views are also impractical, is very important to know how to represent in these applications, because generally exploded views and most of the times are not accepted as graphic representations since they don't give clarity and that certainty that I talked about before, about the protection that is sought. Thus, for example, the drawing shows in this part, in this example, an exploded bicycle, and it's not possible to know how the assembled bicycle will look like, nor is it feasible to establish whether the right is claimed for the bicycle, for the wheels, for the share, or for some other part that constitutes a separate product. In this order of ideas, it was rejected, this application. So I think the time is over. Thank you so much. I wanted to present these general issues about Colombian application, which is very different from other countries. And yeah, with more time or maybe with the questions, I can expand more about the difference with other legislations. Thank you so much.
Luisa, thank you. We actually have a lot of questions coming in, and so I'll be asking our next speaker to try to keep it a bit shorter. I'm sorry that you're taking up the rear and taking up less time, because we have about 5 questions which we need to dive into. Dr. Abiola, is your technical, is yours? Okay, I can hear you now. Please go ahead.
Great. I'm very happy to be here with you and to share a little bit about what happens in the Caribbean region. Of course, it's a very broad subject, and I will do my best in 5 minutes to see what we can cover. But I divided it into 3 groups. I'll be able to cover probably 2. And the first one would be tips for protecting your IP and your IP interests in the Caribbean. Let me explain very quickly that when we speak of the Caribbean, we're talking about the 15 countries that comprise CARICOM, and perhaps a few of them that are not part of CARICOM, the Dominican Republic. Within those 15 countries, you've got French-speaking Haiti and Dutch-speaking Suriname. What has happened over time is that there has been the formation of the CARICOM single market and economy. So you can understand that your IP rights need to be protected within that framework. However, at this point, there really is no overarching convention that allows you to do that. So there is not a convention, say, like the Paris Agreement, the Madrid Convention, or anything like that. What happens, therefore, is that you have to protect your interest in every single country in which you wish to, say, register a patent, protect your copyright, and so on. Each country has its own laws, and of course, is signatory to international conventions. So in looking at registering and other IP regimes, you've got to look at what patent conventions, what are the conventions to which the country subscribes. That is the in. And a lot of interesting things happen. For example, someone was trying to do the listing of copyright in Trinidad, and this was an overseas company that wanted to do that. There is not a lot of jurisprudence in that area, and so what the attorneys wanted to do was to take everything to the cleaners. But you still have to be mindful that a license is essentially a contract, and therefore unfair contract terms and restrictions to business and so on will also be applicable. One has to be careful with situations such as those. So in protecting your patents and in protecting your IP assets, say you've got a copyright interest that you want taken care of, as I've said, you've got to go to each country. For some places, it is automatic registration. For others, it is not. If you created something in some countries, well, perhaps the copyright will be given to you automatically. In others, it isn't. And with laws, what you find is that you've got laws dating from 1956 and some from 2018 in different territories. So it's not quite so simple. It is unfortunate that the Caribbean Patent Convention hasn't come into effect as yet, because that would make it a one-shop facility for registering those patents and things like that, which would be applicable across the board, but we don't as yet have that. And so those are some of the things that you'd have to pay attention to if you're going to deal with registration of IP rights within the region. There's also the issue of industrial designs, which is useful. They call it the little brother to patents. And in some instances, you will find that it is better to engage in registering and industrial design rather than the patent. The patent will, of course, give you much broader coverage. The industrial design is limited, depending, of course, on the country in which you wish to register. And then, of course, I mentioned French-speaking Haiti and Dutch-speaking Suriname. They've got different systems altogether, because most of the Caribbean, you would have the common law system, whereas with the other two, they deal with the civil law system. And those are things that you would have to overcome in order to get your business done. The most important takeaway is that you have to be mindful of all of the applicable laws and the conventions when attempting to register your patents, because there is no guarantee of reciprocity. So those are the two elements that I would very quickly reduce my speech to.
Thank you. Thank you for the consideration, and yet in the time you did make very germane points, Dr. Abiola. Okay, please finish up. Please finish up. Are you done?
Thank you. The last point that I wanted to make was about traditional knowledge and the folklore, which of course is what the Caribbean is known for. All of the cultural aspects that are heavily marketed, such as the carnival and the music. There is nobody on this panel that has not heard of reggae. I am absolutely sure of it. You've also got soca. And if you live in the United States, in New York, every year, there is a carnival that takes place on Eastern Parkway, the West Indian Day Parade. Those are important elements of culture that have attracted a lot of interest in terms of intellectual property, what we do with them, how they are marketed, who gets to protect them. And very quickly, I will say that the steel pan was invented in Trinidad, but the Chinese have a patent for it. And it is produced and marketed there. So, dilemma. To give them credit, they have indeed advanced the technology for the production of the steel pan, but it came from the Caribbean. So, in that sense, we are lagging in taking advantage of our cultural assets. And that is something that needs to be very quickly addressed. Of course, this is a matter for policymakers, and they hardly ever get anything done in a hurry. But that's where you have it. Our cultural assets are marketed around the world. You've heard of reggae, you've heard of soca, you know about the steel pan, you know about carnival, and all of the other things. And yet there are issues protecting them, some of which I have outlined to you as lawyers and people who are interested in that field. So those are some of the things that you need to pay attention to if you're ever interested in dealing with that part of the world, our wonderful part of the world. It's 29 degrees outside here in New York, and I wish I were home. Thank you very much for your attention.
Thank you so much, Dr. Abiola. I was actually supposed to spend my last birthday in the Caribbean. I was to have done a cruise to the Bahamas, actually, but because of COVID, that had to be canceled. So I was really looking forward to visiting your part of the world. And I'm sure when things return to normal, I will still do so. In fact, I have an invitation to come around as soon as things open up, come around to the Bahamas. And what you did say about the single market, as it were, is similar to what we have in Africa. We have today the African Continental Free Trade Agreement, which opens the borders of various African nations and creates the largest single trading bloc in the world today. And so an issue that came up, Diane asked a question during our pre-call conference session about IP protection in Africa because of the increased manufacturing capacity in Africa. And that's an even more germane issue in when you think about the free flow of goods, ease with goods and services can move around freely, beginning from 2021 within the region. And so just like you have in the Caribbean, we do have various regimes for IP protection for each individual country. And therefore, if you want to exploit this market, you have to know about those laws. Now, we've done a study on 4 different major markets within that bloc. Nigeria, which has the largest population, followed by Egypt, which has 100 million people. We also looked at Kenya and also South Africa. Interestingly, when you're thinking about bringing your manufactured products to any market within Africa, you don't only have to think about IP protection, but maybe about costs, import duties, value-added tax, and things like that. And so our analysis shows that the highest VAT rate in the region out of these four countries is Kenya, followed by South Africa, then Egypt, and Nigeria has the lowest value-added tax rate. So that's something to think about. What's the cost of bringing these goods to market beyond protecting the intellectual property? What's the landing cost, the import duties? How easily can you take them to the final consumer within those markets? I want to take some questions if we do have time.
Yeah,
do we have time for questions?
6 minutes are there. You can take like a
have,
couple of questions over here, and rest you can answer on the chat box.
Okay, thank you. So we have one from Irina Rejenko. I'm not sure I got your name correctly, but it says, how do you resolve issues with orphan works when copyright owner is unknown? So I think that should be directed at Diane. Orphan works, that is, the copyright owner is unknown. I would think that it's very difficult to protect those kinds of works, but I'd like to hear what Diane has to
if you
say
don't
about
have
that.
If you don't have a known author, there's no way to protect it, because you have to either the author has to apply, or you have to have an assignment from the author, and as a works for hire or something, at least in the US. So I don't know of any way that you could copyright a work without identifying an author.
I think that should be the answer. And this goes back to Dr. Abiola's issue on folklore and such traditional works, because very often we don't know who exactly developed that that work. And it might be a community or something. How do you kind of say this came from this individual? So I think those are some of the challenges that we might have had. And I think even in African communities, we also have some of those challenges. How do you identify the author of a given work? I also have a question by Emmanuel Kediber. What is best, design or copyright protection defense in a design case? Under the OAPI law, a design protection also benefits from copyright. That's a bit of a technical question. Maybe Louise or Stephen, do you understand the question, and can you attempt what's best, design or copyright protection? Or maybe we can take that conversation offline, because it might require a bit more brainstorming.
Well,
does anybody want to have a go at that?
Currently, if let's say you have a pattern that you sold on the back of a chair, under design law you have to protect the chair, but under copyright you can only need to protect the pattern. So that's the difference. But going ahead, when we allow partial design, we'll be able to disclaim part of the chair and focus on the pattern itself. So I guess either one will work, but copyright has a longer term of protection. Design is valid for 10 years in China, which will be extended to 15 years, but that's it. Yeah. And there's a novelty issue. You know, when you disclose your copyright or design before you file a design, you lose the novelty of the design, but copyright, you don't have to worry about it.
I mean, and I think that really the question highlights the importance of pursuing both. And copyright protection is so inexpensive generally that it bears the lesson of doing both, because that really is the way to augment your total IP protection for a product or a design.
Yeah, it's the same in Colombia. So I agree with both. It would be possible to do through both systems, but copyright, as Stephen said, copyright, the term extension is more amplified. So yeah, but I agree.
Thank you all. I think that you've done justice to that question. We have another question that says, what design elements are in software patterns? I'm not sure. Maybe Hongming, do you have an idea?
Actually,
you spoke about software.
Mentioned a little bit about it. It's the graphic interface. So the interface part can use design pattern. A lot of software companies are using that, but like I said, it's difficult to separate these two parts. It's one difficult issue of software pattern overall. So to touch a little bit about Dr. Abiola mentioned, I think some especially pattern like we have this problem of like when you have a hammer, everything looks like a nail, right? So we are trying using pattern to cover too much. So in software, a lot should be covered by trade secret, like somebody mentioned. So not everything should pattern. Also, the culture aspect, pattern should be staying away from a lot of area. We should probably find less pattern on certain area. That's my point.
All right, sure. I think Chike has lost Chike. There's some network problem. So we have one more question from Siva for you, Hongming, if you would like to answer on the chat box from Siva Manoharan. So on the right, you can see the question is directed to Hongming. At what point would Tencent make the call in assigning a novel SW algorithm to be a trade secret as opposed to a SW patent?
Yeah, that's actually a difficult issue. Not just Tencent, a lot of companies, it's hard to draw a line. So people end up just filing whenever they can. So in a lot of cases, software patent might not be the best way to go, but overall, you see a company get into competition mode. So you have X number of patents in certain area. So that's in my opinion, 50% of the software patent filed should go into trade secret instead. But I don't get to draw the line all the time. So the answer is, yeah, it's tough. There's no clear rule to draw that line.
All right, sure. So I think we have already running up with the time now. So it was an interesting sessions because there were so many questions in the chat box. So it's a very, a very pressing topic for everyone to, know about it, and interesting topic. So thank you everyone for joining. Chike, can you hear us now?
I got disconnected for a bit there. Sorry about that.
So Hongming answered the question of Siva. So he answered, and the questions which are left, I think we can write down on the chat box before we are leaving this page, so they can have an idea on that. So quickly, thank you all for joining for this wonderful session, and I hope it should, extended. It should be of 1 hour because it has been an interesting topic and so many questions on the chat box, as you can see. Thank you so much. Thank you all for joining for this wonderful session. Thank you so much.